In this lecture, we begin the governance section of Principles of Company Law, and we'll begin by looking at directors and their duties. We'll look at the general powers of directors and the limitations on those powers, and then we'll look at the duty of care and the fiduciary duty. Both of these duties are court-crafted and will be based primarily in case law, although the duty of care now does have a statutory frame. Finally, we'll look at some ordinance provisions which tend to restrict directors, require them to behave in certain ways, and also impose limitations on exclusions of liability. So the board of directors is our focus, and it will be our focus for the next few meetings. Some terms that are useful for you are shadow director, which could be deceptive in the sense that you may think it's a director who is not registered as a director but seems to behave as a director. Actually, the statutory definition requires the person to be controlling the board in some way. Although, of course, they are not registered as a director. So the power is more extensive than that and normally ascribed to a director. Responsible persons is something that was introduced in the newest company's ordinance, and it does not refer only to directors, but all persons who have a particular task. And usually those tasks are the task assigned by the ordinance, and usually those tasks are registrations or filings with the company's registry. So we'll look at statutory duties. I won't go into that in any more detail, and we'll also look at duty of care and fiduciary duty in great detail. A conflict of interest is essentially what we're looking at with many of these duties, in the sense that the director has some personal interest which conflicts with the interest of the company, and therefore when we have a separation of these, the personal interest will work against the interest of serving the company and the duty to serve the company, and that's exactly where problems may well arise. A couple of cases on the shadow director, because we will not be looking at this in great detail in the cases that we study, but just remember that it is someone who will be controlling the board, although not be registered as a director in any way. And you might want to think of, perhaps you're going to need some sort of an informal control mechanism. That could be a family outside of the formal governance controls and the economic controls within the company. It could be some other sort of a group, but the person is in that group and has that influence, but is not registered as a director and has no formal position as a director. The board of directors is something which is required by the ordinance, although the ordinance does not specify how the directors will be placed in the board. That will be done through the Articles of Association. It could be by election, but it doesn't necessarily have to be. So with a public company, we need at least 2 directors, and with a private company, we need at least 1. It is possible to have a company acting as a director, so a body corporate may be a director in a private company, which is in no way affiliated with public companies. A public company may not have a body corporate director. Directors have to be at least 18 years old, so I think most of you would be easily qualified as a director. And then directors must be proposed individually. That is, we cannot say bundle together for election directors A, B, and C. And if you vote for A, you must also vote for B and C. That sort of thing is not allowed. Right? And other than that, there are very few statutory rules regarding directors, but we do have quite a few rules referring to the board and the duties of the board. So if we look at the ordinance and the model articles, we can see generally directors have the power to delegate. In a large company, directors will not be involved in the day-to-day management of the company because there will be employees, executive managers and managers below them, and also experts like lawyers and IT engineers to whom the directors may delegate and whom the directors may trust. The directors are generally in charge of calling the AGM. The directors gather all accounting records that will ultimately be prepared by the auditors. The directors, as we saw in our third lecture, generally have the power to bind the company. This is in section 117 of the company's ordinance, and we looked at that in some detail. The directors keep a lot of registers. They keep registers of themselves, and they also keep registers of the members and of debenture holders, among other things. And in extraordinary, very extraordinary circumstances, the directors have the power to wind up the company, but this is something really reserved to the members in almost every case. So we see there is an edge to the director's power as it dissolves into the members' power, and the members generally have authority over the larger decisions, changing the shareholding structure, changing the constitution of the company. So directors in a large company will be the top job, and a director will be a powerful individual. They're used to dominating the groups that they're in. And so when you have someone who is powerful, clever, and accustomed to dominating others, then this is not an easy person to control. And that is exactly what we'll be looking at today, is our first look at how directors are caged in. So the constitutional documents, as we've discussed in particular in our second meeting, are a tool that we use to limit directors' power. The capital measures, as we've looked at in our recent meetings, are limited to shareholder control, not board control. The tenure in office can normally be specified in the Articles of Association to provide for relatively frequent elections, and that will keep the directors on their toes looking for re-election. Self-dealing under Section 536 of the Companies Ordinance must be disclosed. And then we have a number of other rules against self-dealing, such as directors granting themselves loans and credit. And then the directors should hold regular meetings and among themselves. And of course, there is an annual general meeting which must be held, and they must provide detailed information, the director's report, that we'll look at later in the course. So the duties of directors is our key focus today, and much of the activity will be in case law, but the duty of care has been placed in statute, and let's look at what duties are and how the duty of care functions. So there's a different standards and duties are essentially a broad legal tool which allows the person subjected to them to have some freedom, some flexibility. Imagine a speed limit, 80 kilometers an hour. If we have a speed limit of 80 kilometers an hour, then that speed limit will be clear. And when we exceed it, we will be breaking the law. And when we do not exceed it, we will not be breaking the law. If, however, we had a speed limit, as say they do in Germany in some areas of the Autobahn where there is no speed limit, the speed limit is essentially that you may drive safely as your car, the traffic conditions, and weather allows. That's an open-ended sort of rule, and to apply it, we'll have to know the facts about the person's car, facts about the number of cars on the road, that is the road conditions, and also the weather conditions. And so that's something that comes close to a judicial type of decision. It cannot be automatic, right? So a duty is an obligation corresponding to another person's right, and a fiduciary is someone who must act for the benefit of another person, right? So a duty of care is something that we see applied to skill sets. Drivers, physicians, and directors must all meet a duty of care. And fiduciaries The highest form of fiduciary is a trustee in a trust, but also we've seen this already with partners in a partnership are fiduciaries, and the directors are fiduciaries to the company. Right? So therefore, we have a duty of care and a duty of and a fiduciary duty, and they run to the company. So standards express these duties, and here I basically just summarize again what I've already said briefly, that the duty of care is essentially looking to skill. It's looking to whether the director is behaving negligently. Please do not confuse this with what you know about negligence in torts. This is a specialized type of negligence standard, and we will only, in this course, and you will only, in company law, be dealing with the duty of care when you discuss this. You will not be going into general application of a negligence rule. A fiduciary duty derives from a relationship of trust, as I said, and essentially it requires the director to put the interests of the company before his or her own interests. So these are essentially judicially crafted checks on power. I give you this point just to teach you something about how common law interacts with an ordinance. Now you know that common law tends to fill in the gaps of an ordinance, and you also understand that common law will be effective where there is no ordinance. So the ordinance can also deliberately leave a particular area open so that common law can fill that. And directors' duties has been an area where the law applicable, that is the statutory law applicable to companies, has been left open, and the courts have crafted it on a rolling basis as cases arise. So essentially where you have a power, that power can be abused. When someone complains that the power has been abused, in fact, that the exercise of the power is not legitimate, then the court can look at this particular exercise of the power and decide whether it should be restricted. And the restriction will take the form of a duty. And as I said, we have duty of care and we have the fiduciary duty. So it's an interesting question to whom the duties are owed. So let me begin with the second bullet point that you see on this slide. You see that in the UK, there has been a move toward the US model. In the US model, the duties are owed to the members of the company. The US has some problems with coherency because it both recognizes the company as a legal person and fails to recognize the company as the legal person to whom the duties are owed by the directors. This leads to a good situation for members in the sense that we've brought the US law to a point where the directors in the company as a whole essentially have the function of providing cash to members in the form of dividends rather than producing products. This is the kind of problem that if you've been watching the news about Tesla, that Elon Musk has been highlighting. Because in most countries, the directors work for the company produces a product, the product produces profits, the profits can be distributed to members. Under the US model, the product and the company itself seem to be excuses for the real purpose, which is simply to somehow give the members money. And this has led to a quite dysfunctional corporate culture in the United States, where companies borrow large amounts in order to save on taxes and pay those amounts to their members. Now, in Hong Kong, the duty of care is owed to the company. This was the old UK law as well, and it's similar to the law that you see in continental Europe, where the duty is owed to the whole company, which would include employees and a number of other elements of the company. So in Hong Kong, it's owed to the company, and that has not been extended to, say, the employees of the company. The duty is not owed to individual members unless there is some sort of an individual contract. And I apologize for giving you reference to a case without reading that case, but you here have the Percival and the Allen cases, which are two citations that will take you to rules about the directors not owing a duty to individual members absent a contract with those members, aside from what's owed under company law. So the former subjective duty of care, we could call that the sleeping director rule. And this also shows an era when the class of persons owning and directing companies was considered to be a better group of people who may go to the same clubs as the judges and be treated with a certain deference, because we don't want to push these people too hard. We know, after all, they're the same sort of people that the judges are, all very good people, and not like the other people who aren't able to run or own companies. So in this sort of rule, which was adopted in the 1920s, we have a director who essentially only has to be himself. And I say himself very clearly because there were no female directors in this age. And so the director simply must do what that director can do. That is, if that director likes to sleep in a meeting, that's fine. If that director likes to avoid mathematics, that's fine. If the director does not like to read the documents because it makes the director bored, that's also fine. So this is essentially can be considered to be the sleeping director rule, and that is no longer the law.